It's great to welcome Kolarele Sonaike onto the channel. Kolarele is a barrister from One Essex Court, and one of Kolarele's key areas is employment law. Kolarele is going to provide some tips on employment tribunal advocacy. Thank you so much for joining me, Kolarele.
And Matt, thank you for having me on. As I said to you, I love the stuff that you're doing. I really think it's important to make the law much more accessible, but there's actually very few of us doing it in the profession. So really appreciate you having me on for it. And also to talk about employment law and employment tribunal advocacy, which is a real passion of mine. I've been a barrister for, 23 years now, and I've done employment law from the start. So it's the kind of law that I love to see when it's done well. Sometimes it hurts when it's not done not so well, but I think that's as a result of a lot of misconceptions as to the best way to approach it. So I wanted to provide a couple of tips that I think will be useful for anyone facing an employment tribunal claim and wanting to know what's the best way to go about it. And this is kind of my process. So the first thing that I always do is work out what's my narrative, what's my story for the claim. Although we think about law as very much about logic and the right legal outcome will present itself, I think especially in employment tribunals, we often forget that it's people involved that are going to determine the case, whether it's the judge or the judge and lay members. So I always start with what's the narrative, what's the story that this case is about, and frame it in a way that means if they buy into the story that I'm trying to present, they will find for me or in favor of my client because I've led them down a path and down a journey that just makes sense to them. So kind of the first thing that I'm always looking at is, okay, what's the story of this case? Who are the characters? What's the plot? Who's the villain? Who's the goodie? That kind of thing. Really thinking in those terms, just so that I start to think about the whole case holistically, as opposed to just an individual, set of different pieces of evidence that won't necessarily make sense when they're put together. So that's the very first thing I do. Before I even delve into the detail, it's just what is the whole story here and how am I going to frame it in a way that just makes sense for the tribunal as they kind of go through the trial. So that's the first thing that I do. The next thing I do is deep preparation. And by deep preparation, I mean, so this is me personally, I get obsessed with it. I'm a geek about it. I look and analyze everything to the last degree. So I have a great short-term memory. So whilst I'm in the middle of a case, I know everything about the case. The minute the case is done, I can tell you almost nothing. But that's because I do deep analysis. So I will read every document carefully. So often you may have a folder, of papers where the trial bundle is, 1,000 pages long, whatever, and the case will come down to 2 paragraphs on 2 different pages. If you haven't done the deep analysis, the deep preparation, looking in detail at it, you just won't spot those things. And then you will kind of be in the zone where the issues that could have helped you win the case, you're not fully on top of. And so it becomes much more of a battle than it needed to be. So my next kind of step is that deep analysis. So typically I will read the documents before I read some of the pleadings, just to get a sense of, okay, well, what is going on here without what have the pleadings already said? What have the parties already said their case is about? Then I'll actually look at the pleadings and read, okay, right, so they're saying it's this. Did that fit or gel with what I thought when I read the documents? I do that because actually, if you do the pleadings first, which is usually, and it's not I'm saying don't read the pleadings, but very often you will then be training your mind to only look for the things that the pleadings themselves have identified, as opposed to looking at all the issues that are in the case and then seeing what it is and how they fit with the pleadings. So that's my personal process. So I'll look at the documents, then I'll go through the pleadings in more detail. Then I'll look at the witness statements. Then I'll go back to the documents, and you're trying to cross-refer, really put everything together. I always do a chronology because that always helps me plot what happened when and refer it back to kind of the pages in the bundle and things like that. So my step number 2 is deep analysis. And this is basically where cases are won and lost. So you can't do too much analysis is kind of my rule of thumb on that. So once I've done the deep analysis, before I then go on to things like preparing my cross-examination, I will do or prepare my closing submissions. Now, why do I do that? So very often people think about, okay, I will prepare chronologically. So I'll start with the pleadings, then I'll look at the documents, then I'll do the statements, then I'll cross-examine, then I'll do the closing submissions. But if you think about it, the closing submissions is where everything is brought together. But if you don't know that that's where you want to end up, then you're not going to be preparing your case in light of the ending that you want to achieve. So before I start preparing cross-examination and things like that, I will very often look at my closing and prepare what are the things I want to be able to say when I'm giving my closing submissions, which is the last thing I'm going to say to the judge after I've set everything else up. And once I know that, then I know it's time to start preparing for my cross-examination. And I'm preparing cross-examination and even evidence in chief and what I'm going to try and get out from the witnesses in light of what I need the evidence to be. The useful thing about that is cross-examination, when it comes to it, is the single hardest technical skill there is when it comes to advocacy. The skill of taking a witness who doesn't want to help you and guiding them, crafting them, persuading them, manipulating them, all those kind of different things into giving you the evidence you want is extremely difficult, but far harder if you don't know what it is you want to end up doing. So a good kind of point is, because I know my closing submissions are going to be, very often there are points in their evidence that I won't even challenge because I know challenging them doesn't do anything to help my overall case. So I prepare my closing submissions, and that's kind of step 3 from my preparation for advocacy. And then step 4 is the actual detailed preparation of cross-examination itself. And that's just about looking in and following the golden rule, which is never ask a question to which you don't know the answer. Or if you don't know what the answer is, you know the answer possibilities and you have prepared for each one of those different possibilities. I can guarantee you, the minute you ask a question that you don't already know the answer to, they will give you an answer you weren't expecting and it will throw you off everything else. So you really want to have been prepared in terms of your closing submissions and then do the deep analysis of your papers again for cross-examination purposes. Now, when you're cross-examining a witness, you really are just trying to guide them to give you the evidence that you need. So it's not that cross-examination has to be cross-examination. You don't have to be angry at your witness. If that helps to destabilize them, sometimes you can use that. But invariably, you will get far better answers for your case by being non-confrontational, but intellectually aggressive. So you're just asking questions in a way that nobody could object to the tone, but they are very forensic and they're very targeted, and they're leaving your witness with less and less room in which to maneuver until you get them to exactly where you want them to be. And the evidence is exactly what you knew it was going to be through your cross-examination. You have to be very patient, very careful. You have to listen in particular to the answer that's given and adapt to that answer as it goes along. Don't try and ask questions and not listen to the answer, because then you'll get an answer that's slightly different to what you'd prepared for. So be very careful and forensic with your cross-examination, but be intellectually aggressive. So you are pushing and pressing your witness to give you the evidence that you actually need. And then when it comes to tying it all together with your closing submissions, you want to remember that narrative, that story that you had thought about when you had prepared your case, and really speak to them in light of that cross-examination, in that light of that narrative rather. And in terms of kind of final tips on closing submissions, one of the things that I always think is important and is underestimated, because as lawyers, we're trained to really look at what's logical and what's the evidential basis for any fact we want to establish. But actually, beyond just establishing the facts of the case, you want to give your tribunal an emotionally compelling reason or basis to find in your favor. So even if it's something like, these are the facts and so forth, and also the decision you make is so important because it's going to have this kind of impact on my client's life, make sure you give them that emotional reason as well as the factual and evidential basis for what you want them to find. Because otherwise it leaves them only thinking about logic, and logic is just not the most compelling way to persuade people. Typically people, even judges, are swayed to an extent by an emotional narrative and emotional imperative. Don't rely only on that because judges can see through it. But if you have a good evidential basis for your arguments, and then you combine it with an emotional imperative, that just gives your judge a bit more of an edge to find in your favor. And then once you've made your submissions, it's the waiting game. And that's the hardest part because, you know, they could take 10 minutes, they could take 10 hours before they come back to you with a decision. But once your job is done, all you've got to do is wait and kind of see the outcome. So that is my process, which has produced pretty good results so far. I hope it works for your viewers. I hope they find it useful. And yeah, good luck to all of them in their employment tribunal cases.
Well, that's great. Thank you so much. It's a real art. Obviously, practice makes perfect, but for what you're saying, it's a real art that you have to craft. And it's very helpful what you said. So thank you. Thank you for coming on the channel and sharing all your experience and knowledge. Thanks a lot. For more information, do browse this channel and visit my website. Remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And finally, please subscribe to my channel for updates.